Aloha, this is Professor Porter. We're talking about the Federal Rules of Evidence. In particular, we're talking about hearsay and definitional hearsay under 801C. If you think about just the definition, arguably the most important definition that you learn in law school based on the way it's treated in the course of evidence and the way it's treated on the bar exam, very simple. If you don't get wrapped up in all the exceptions, all the exemptions, and the ins and outs of the rule, if you keep it just like a flag that you would throw for any other objection, the opponent owns this objection just like many of the other rules. Objection hearsay, and what the opponent is saying when they say objection hearsay in open court is that they have the foundational requirements, the elements of that objection, that it's out of court, it's a statement, and it's offered for some bad purpose. That is, the proponent's trying to offer it to prove the truth of the matter asserted. Another way of saying prove the words in quotes, the contents of the words in quotes that come from the declarant who made this out of court statement. So really, if you think about it from the top line here, the opponent is saying objection hearsay. They're saying they meet the definition. They're saying we want to make an argument that the proponent is doing this for the bad purpose, that they are offering this for the truth of the matter asserted, for that definitional part of hearsay. And then everything else in the rule really belongs to the proponent, and it's the way that the person presenting evidence, the person that's putting on evidence, the person that was putting on this statement gets to choose where to go from here after the opponent launches their hearsay objection. And that comes in all these different ways. Now notice that if you look at that second line, it could be the proponent says, this is not hearsay. And that's the way I would start if I were the proponent all the time. I would start, if I was the second line and I was arguing definitional hearsay, Your Honor, this is not hearsay because maybe it's not a statement. Your Honor, this is not hearsay because maybe it wasn't made out of court. Those are two things you can say as it relates to the first two elements. If there are foundational requirements of a rule, the proponent can always respond to that. Here are my foundational requirements, and I say you don't have them. Your Honor, this is not hearsay because it doesn't meet the definition, because maybe it's not out of court or it's not a statement. The most popular one, and if you're guessing at home, always has to do with the proponent's purpose. The proponent, what are they trying to prove? What are they trying to do with the evidence? So if I were guessing at home and I was responding as the proponent and I was doing so on against the definition of 801C, I would say, Your Honor, this is not hearsay. This is not offered for the truth of the matter asserted. Instead, and it's offered for some other purpose other than for proving the truth that's in quotes. Further on in the patchwork of the things that the proponent could say, of course, the proponent could go to definitional non-hearsay, definitionally things that are the rule makers decided are not hearsay, or they are exemptions to the hearsay rule. That's 801D. That has to do with prior statements, either prior inconsistent statements or prior consistent statements, out of court identifications, and then the whole world of statements by party opponents, those statements that are made by party opponents, those statements that are attributed to party opponents through various exemptions. So again, if I'm the proponent, I have a few different things I can say. I can say that it doesn't meet the definition. If I'm guessing at home, I say it doesn't meet the definition. It's not hearsay because it's not offered to prove the truth of the matter asserted. I'm not offering it for that bad purpose. I'm offering it for some other purpose. Or maybe the last one in that second line, I have my own definition. I have my own exemption that's spelled out in 801D as something that's not hearsay defined. If the opponent says this is hearsay defined, out of court statement, truth of the matter asserted, and the proponent makes their way over to sidebar and says, no, this is not hearsay defined under 801D, and they have their own foundational requirements for either prior statements or statements by party opponents or out of court identifications, those not hearsay definition, should they meet those foundational requirements, are going to win out, and the statement's going to be admitted, and it's going to be admitted for its truth. It gets to come in for all purposes. The last thing, and this is sort of a checklist and a pecking order, the last thing that the proponent can turn to are the world of objections, the world of exceptions. Either 803 exceptions that really have to do with, these are narrow instances where we say the circumstances surrounding the statement are reliable enough to allow it in. It's not a guarantee of truthfulness. It's not a guarantee of reliability. We just say these circumstances are reliable enough. Then the 804 exceptions that have to do with necessity. We have unavailable declarants, so we need these statements to come in because there's no other way to do it. And then just to round it out, we have a catch-all that has to do with residual hearsay under 807. So the top line is what is said by the opponent. They always say the same thing as it relates to hearsay. Objection, hearsay, go over to sidebar, and really what they mean is this is an out-of-court statement for truth of the matter asserted. The rest are options for the proponent. Maybe they can say, nah, you don't have that exception. Maybe it's not hearsay because it's not a statement or because it's not out of court. Most popularly, it's not hearsay because it's not offered for the truth of the matter asserted. Maybe they have their own definition of not hearsay under 801D. And lastly, they can say, yes, this may be hearsay, but an exception applies, either 803 exceptions, and there are many of them, 804 exceptions that have to do with unavailability and necessity, or a catch-all exception in 807. These belong to the opponent. These belong to the pro. So first, we're arguing that definition. Yeah, we can say, Your Honor, this is not hearsay because it's not out of court. If a opposing counsel, the proponent stands up and says, you were asked questions on cross-examination earlier in court today. Objection, hearsay. Your statement's going to be, Your Honor, this is not hearsay because this was not made out of court. They made the statement here in court, albeit it was during a different examination. Objection overruled. You may proceed. Maybe it's not a statement, and it could be a question, it could be an exclamation, it could be something that's not a statement. Maybe it's a nonverbal conduct that's just not assertive. It wasn't that the declarant was intending to say anything, and you'd be arguing that it doesn't have a definition. The real one that's the point of this video and everything else is when you're arguing that you're arguing the definition. You're saying, Your Honor, this is not hearsay. This is not offered for the truth of the matter asserted. There's like a top 5 that you can go to. And it's the top 5 that come out. These are published in cases. They're not in the rules. But when you're saying, as the proponent, Your Honor, this is not hearsay. It's not offered for the truth of the matter asserted. I'm the one offering the statement. I'm the one presenting this evidence. I'm the one that asked the question about the quotes that someone else said. I have another reason. I'm not trying to prove the words in quotes. I have another reason. And here are the top 5. Its effect on the hearer, right? I'm not offering it for the truth. I'm offering it to show what the people that heard it, the listener, the hearer, what they did next. State of mind, and really what you can put as a parenthetical before this, circumstantial evidence of the declarant's state of mind. I'm not offering this as the proponent for the truth of the words in quotes. I'm offering this to show what does it say about the person who said it. They could have a bunch of gibberish that comes out of their mouth. I'm not offering it for the truth of that gibberish. I'm offering it to show, let's make a conclusion, let's make an inference circumstantially about what that means about what's going on with the declarant. Next one is impeachment. We talk about impeachment a lot in several other videos, but for our purposes here, if someone says something on equally reliable circumstances, they say different things on different days, then we can point that out and we can essentially say, we're not offering that for the truth. We're not offering that prior statement for the truth. We're offering it to show they say different things on different days. So therefore, it's impeaching. We can comment on that credibility based on that impeachment. We actually don't care which one of those statements is true, so we're not offering it for the truth of the matter asserted. A legal act, verbal act, probably the lesser of the 5 options here of sort of non-truth of the matter assertive argument. And essentially there are some statements that have independent legal significance. An offer in a contract, an acceptance, a proposal, a marriage proposal is a popular one. Those things might have independent legal significance. So essentially what you're saying is, this isn't offered for the truth of the matter. This is the offer that's at issue in the case, in a contract case. And lastly, having to do with putting someone on notice or someone having knowledge. These can get tricky, but it provides arguments for both sides. Essentially, we're not offering this as the proponent for the truth of what was said when we told the store owner that the sidewalk was slippery. Instead, we're offering it to prove that at least the store owner was on notice, that they had knowledge that it was slippery at some time before the accident.